All right, so now we come to a current case in hearing, Held v. State of Montana, a youth-led constitutional lawsuit that started off in 2020, where 16 young people from across the state of Montana, represented by Our Children's Trust, Western Environmental Law Center, and McGarvey Law, asserted that supporting a fossil fuel-driven energy system, which is proven to be contributing to the climate crisis, is violating their constitutional rights to a clean and healthful environment. Also, to seek safety, health, and happiness, and to individual dignity and equal protection of the law. The youth plaintiffs also argued that the fossil fuel energy system is degrading and depleting Montana's constitutionally protected public trust resources, including the atmosphere, rivers and lakes, and fish and wildlife. A year later, in August in 2021, the First Judicial District Court ruled in favor of the youth plaintiffs that they could proceed to trial, denying the state's motion to dismiss. And I just wanted to, that's the case that you see. Here's where a few key findings were provided by the court, which you can read here. And I just wanted to quickly, a couple more procedural history points. Last year, June of 2022, the Montana Attorney General filed 2 emergency requests to take supervisory for the court, the Montana Supreme Court, to take supervisory control of the case away from the trial judge and issue a stay to block discovery, just as numerous depositions of expert witnesses were scheduled to begin. The Montana Supreme Court denied those requests, stating that the Attorney General's request was, quote, at best disingenuous, quote, and explained that supervisory control was an extraordinary remedy for gross injustice. The court rejected the state's arguments and ruled that the state was attempting to manufacture urgency or emergency factors to fulfill the necessary criteria to justify their request. So fast forward to today. The trial is right around the corner, June 12th through the 23rd in Montana. And it is what Our Children's Trust described as an historic trial, the first children's climate trial in U.S. history. So it's safe to say that all eyes will be watching how that pans out. Here's Maya with New York.
And I just want to add really quickly, one of the things we've seen other youth climate litigation actions being brought at the state level and the federal level. And in a number of states, we talked about how there are all these states with language, but it's not Green Amendment language. And it very commonly what we see is ultimately when there is that motion to dismiss, it's granted because that constitutional language has those fundamental failings that we've talked about, right? Where the power is with the legislature and where it is policy. It's not that individual entitlement. And so what makes the health case so important in this Green Amendment context is that it is now a state that does have a Green Amendment where this case is being pursued. And that Green Amendment criteria and language was critical to helping ensure that the motion to dismiss by the state was defeated because the youth do have that individual entitlement that they can pursue in the court. So that's one thing that's so valuable. And I'll just note that I'm planning to be in Montana and to be writing about what's happening on the case. Not commentary, not assessing the law, because that would not be fair or right. We want our Children's Trust attorneys and the Western Environmental Law Center attorneys to do all that good work. But just to say, this is what was said today. So anyway, so just a matter of interest. If you follow Green Amendments for the Generations, I'm hoping that there'll be some interesting information sharing about what's actually happening in the courtroom. Now on to New York. So New York, we are starting to see a couple of cases emerge, and they are providing helpful insights. And those insights into what it means to have a Green Amendment are just affirming, reaffirming, and confirming what we see in Pennsylvania and Montana that results when you have this kind of constitutional entitlement with the Bill of Rights placement and the appropriate framing in terms of the language. Just going to talk about two aspects of one case. This is a case involving a massive landfill where the State Department of Environmental Conservation has allowed the landfill to continue its operations and to expand in ways that are resulting not just in significant odor, but in dangerous hazardous substances being released into the air in terms of air pollution, as well as greenhouse gas emissions. The local impacted or the neighboring impacted community, represented by Fresh Air for the East Side, they had sought previously through advocacy and through law to try to challenge the ongoing operations and the continuing expansions of this landfill. And they had always failed. Their efforts had failed. After the New York Green Amendment was passed, the New York DEC rendered some new decisions that allowed the continuing operations and or expansions and failed to do anything about what was happening at the site and resulting in a violation of the rights of the people to clean air and a healthful environment. And so this legal challenge was filed based on the New York Green Amendment. The state sought to have the case dismissed, in part saying, been there, done that. That case was already decided. This is from the past. But the New York Supreme Court, which in New York is the lowest level court, it's not the high court, actually said no. There are ongoing, continuing, present day actions and decisions by the state that are being challenged here. These are not just actions of the past pre-New York Green Amendment. And so, want to be clear that this is ongoing current action and activity that's being challenged. So it can't be dismissed based on the fact that this is just past action. I do want to note that there was another recent decision that just came out that actually did have that determination, that the challenge was based on past actions pre-Green Amendment that had already been decided upon, and there was nothing new or different or happening today that the challenge, the Green Amendment aspect of the challenge was grounded in. And so there the court said, no, doesn't work retroactively. But here we're not talking about retroactive action. We are talking about current day actions, activities, and or inactions that are allowing the problem to happen. So that's really important. We also have some case law in Pennsylvania that makes clear inaction can be deemed action. So I just want to throw that in here. But the court was clear in resisting the motion to dismiss that the New York Green Amendment is self-executing and enforceable in its own right, regardless of what's happening, whether or not there's legislation that specifically defines it in a specific context. They were clear that the obligation applies throughout government. It's not just the state legislature, and that it really is appropriate for the courts to have a role in this kind of decision making because we are talking about a constitutional entitlement. The court then also visited the idea that the court can grant a remedy for this kind of constitutional challenge. The remedy might be the kind of remedy, it's all the things we've been talking about. Permits are voided, right? Or rescinded. Laws are deemed unconstitutional. So courts can provide through declaratory action and equitable remedies can provide meaningful remedy to these kind of constitutional claims. There was also an aspect of the case that had to do with the town and the town's role in what was happening with regards to this site. And due to time, I'm not going to go into it, but really it's just, it's more of the same, self-executing, etc. But there too, the court did spell out a possible two-pronged test, being that first, did the government action comply with the applicable statute? You answer that question. But second, did the government action violate a person's constitutional right to clean air and water and a healthful environment? They are two separate questions. They're complementary, but they are separate and both have to be answered. And then just want to highlight that one of the things, that we really like to stress about Green Amendments and their benefits, it's not just about what the outcome you can get in the courtroom. Actually, the best power and benefit of a Green Amendment is that we avoid the courtroom altogether because we're getting our government officials to make more informed, better government decision making. If the Public Utility Commission in that LNG transfer station had thought about the environmental environmental implications for the municipality, they could have rendered a better decision, perhaps, in that case. Maybe the decision would have been a no to the transfer station, or maybe it would have been a yes, but with better protections for the environmental ramifications for the community. We would have had better outcomes and avoided the need for litigation, for example. But we have seen municipalities using the Green Amendment to render better land use decision making. We've seen the Pennsylvania government ground critical PFAS drinking water protections in his Article 1, Section 27 constitutional obligation. We've seen the Pennsylvania Attorney General routinely cite the Pennsylvania Green Amendment to support enforcement actions. We see residents and people raising the Green Amendment in their advocacy, and we see government officials utilizing the Green Amendment to render better decisions so we can get better protections and avoid the courtroom altogether. So Mel and I just really wanted to highlight that critical aspect of a Green Amendment. And go really quickly over, there are a lot of frequently asked questions. We identified just a few of them. Every state where a Green Amendment is being challenged, it's always the same kind of challenge. And we have good answers to all of them, because there is no good challenge, truly no good challenge to people having a right to a clean, safe, and healthy environment. We all know that we're entitled to that. We all know that we need that. We all know that that's meaningful and powerful and important and is a true entitlement of all people here on this earth and here in the United States of America. So the challenges, tend to be similar, and we have good answers for them all. First, one of them is that we're going to see massive frivolous litigation, and the floodgates of litigation are going to open. Well, we haven't seen any frivolous lawsuits grounded in the Green Amendment in any of the Green Amendment states. And we also have not seen this massive onslaught of litigation writ large. We've seen meaningful legal challenges that are serious and significant and should be benefited by additional or can be benefited by additional judicial review, and having the courts weigh in is making a difference. What we have seen in terms of the number of courts on average or the number of cases on average that make it into the courts in the 3 states that have Green Amendments, less than 10 a year. There are some cases that are brought also at the administrative level and handled at that lower level. But of those that are actually making it into the courts, less than 10 a year on average in those 3 Green Amendment states. We hear that the language is too broad. All fundamental rights language is broad, so that it can stand the test of time and cover all of the issues that need to be covered. If we look at any Bill of Rights provision, we see broad language, free speech, unreasonable searches and seizures. The list goes on and on. Green Amendments are no different. And in fact, when you have that generational language and that trustee language and all the other elements we talk about, actually Green Amendments have a lot more specificity than a lot of other provisions that we see in the Declaration of Rights section of our state and federal constitutions. Green Amendments are not about neighbor attacking neighbor. Unless you have specific language, like in Montana, most Green Amendments are about government action and activity. There's a question about what, they say that it doesn't address pre-existing environmental damage. And so for many communities, that's a concern. Like we demonstrated with the landfill case, if there is a current ongoing action or activity or decision making by government officials, then environmental devastation and degradation that started in the past but continues into the future actually can get Green Amendment attention, again, if you have present day ongoing government action. And we actually, quite to my surprise, we hear from attorneys all the time that it's inappropriate to give judges the power to determine environmental law and policy, and that there's no place for them when it comes to constitutional environmental rights. That's about the most absurd, insulting thing that I ever hear, particularly when it comes from a lawyer. So please, Don't ever say that if you're trying to challenge a Green Amendment proposal, which I hope none of you will, right? U.S. courts have an essential role in ensuring the proper interpretation, application, and enforcement of environmental laws and constitutional entitlements. They have a meaningful, irreplaceable, important democratic role when it comes to considering constitutional environmental protections. It's right and appropriate that they have a place and a space at the table. And we see that they use that authority very appropriately.
Okay, so we have about 15 minutes till the end. We wanted to, shave some time off for Q&A, but let me just get through this last takeaway of our agenda item. How to enact a Green Amendment. There are different ways to enact a Green Amendment in the state constitution, but I would say that the first step is, of course, awareness. People need to know and understand why their laws are not enough, why the status quo is failing. They also need to see why Green Amendments are the answer to those points of dysfunction in order to achieve the shared objectives of having and enjoying a clean, safe, and healthy environment. So once there's a critical point of momentum toward this end and a call to enshrine such fundamental rights in the Constitution, the procedures of enacting a Green Amendment will vary depending on what your state allows. So in all states, generally the legislature can propose a constitutional amendment, with 49 of them referring to the ballot for voter consideration. And I believe Delaware is the only state where voters don't need to approve a constitutional amendment that the legislature proposes. A constitutional amendment proposition can also derive from constitutional conventions or commission referrals, and in some states, citizen initiatives can amend state constitutions, like Florida. So in the next slide, I'll provide an overview of Florida's version of a Green Amendment, where we're proposing the right to clean and healthy waters by citizen initiative. But first, very quickly, back slide, Maya, could you update us with your perspective on the status of Green Amendments nationwide? I know you touched on it before, but do you have any other comments to follow up on that?
Yeah, no, just, again, Green Amendment proposals are advancing in about 15 states, with more and more coming on board all the time. For the most part, they are proceeding through legislative initiatives first. So the legislature decides by the requisite votes and the requisite number of times, and then it goes before the people. Right now, it is only Florida that's doing it by the petition pathway, but there's another state that might be coming on board with that pathway soon, being inspired by Florida.
Awesome. And what are your thoughts regarding a Green Amendment in the U.S. Constitution?
So, it's critically important, right? We all know that state governments have a lot of power when it comes to environmental protection. Federal government has a lot of power when it comes to environmental protection. So we need Green Amendments at both levels of government. But we've got a lot of work to do in order to lay the foundation necessary for a federal Green Amendment. And it's not just because of the politics of today. It's because constitutional protection of environmental rights is not something that most people have thought about. Most people think that the law is already protected, that they already have an environmental right by virtue of the laws that we have. And they don't actually understand why we have so much pollution and degradation, right? And that this environmental constitutionalism could be the missing link, that big gap that we need to fill. So we actually, in order to get to the place where 3/4 of the states will vote in support of a Green Amendment, we need to lay the foundation of education and organizing and information. And at Green Amendments for the Generations, it's just, our perspective that the best way to do that is go state by state by state, educating, organizing, seeking, securing Green Amendments, showing them in operation, and we'll be laying the foundation necessary ultimately for a federal amendment.
Awesome. Thank you. All right, so let's discuss very quickly the true adventure that is a citizens initiative in the state of Florida. I could get into this and take another hour and a half of your time to talk just about this, but I'll leave it to you to research on your own time what this is, what it says at FloridaRightToCleanWater.org. But so I'll just skip to the part where I talk about, on the right side, as it relates to Green Amendment's criteria. Well, we did position the amendment to be placed in the Declaration of Rights section, and we ensured it was clearly self-executing. And in it, we recognize the fundamental right of the people to clean and healthy waters and include an enforceable cause of action to seek equitable relief and restorative remedies if appropriate. We couched a violation of the right to include government actions or inaction that harm or threaten to harm Florida waters, which creates a duty to look beyond the immediate environmental impacts into issues embraced by the precautionary and prevention principles, considering how it will affect future generations. And finally, we carefully tailored the amendment to address Florida-specific issues, which there are many. Florida-specific needs, Florida-specific legal framework, which again, we can get into further if there's time and interest. But for now, Maya will close this out.
Great. Only if my little things will come back. So there, my little arrows will come back.
If you're in a jurisdiction that requires a verification code, please write the following code word down. PAD. P-A-D. PAD.
So we're really pleased that you joined us. We hope that we gave you a lot of great information about the Green Amendment movement, and have inspired you to want to be a part of it in a supportive way. Do want to note that Green Amendment proposals in all the states where they're advancing, the language is different everywhere. They meet the criteria, but the language is always tailored to the unique qualities and priorities and personalities and cultures of the individual state where we're working. That is by design. This is not a cookie cutter approach. So if you want to get involved with the Green Amendment movement or help be the leader to advance a Green Amendment in your state, if one's not already advancing, I encourage you to connect up with Green Amendments for the Generations. I'll work with you personally to make it happen. If you want to see what the status is in your state, if you want to learn more about the Green Amendment movement, how it works for environmental justice, climate justice, and all these other justices, then www.forthegenerations.org will get you all that information. And for our most active sites, there is actually a specific Green Amendment website. Like in Delaware, it's www.degreenamendment.org. In New Mexico, it's nmgreenamendment.org, and so on. But you can get to all of those state-specific sites and pages from forthegenerations.org. So with that, we will open it up to Q&A, and we have a question already, Mel, in the Q&A chat. And so I'm going to pose it to you, see if you have some thoughts. And if necessary, I can add some thoughts. So this says, when structuring the text of a Green Amendment, how do you build in safeguards so that it is not used as a vehicle for NIMBYism? For example, someone utilizing environmental concerns to stop low-income housing from being built nearby.
Great. So very quickly, NIMBY, if you're not familiar with the term, is not in my backyard, which is just a general sentiment of, sure, that can happen, but not near me. And that's pretty much that underlines the premise of what we had talked about earlier regarding sacrifice zones, and collateral damage will happen, so it has to go to someone's backyard. With the Green Amendment, that's not true. The onus and the burden becomes on the actor themselves to fix themselves, so they don't, pollute or degrade or destroy something that's constitutionally protected. Okay, so it stops there. It doesn't, we don't have to determine who gets to bear the burden of someone else's profit making. So there is a nice quality of the Green Amendment with the fact that it's treated with such high scrutiny, strict scrutiny, that the question will become, what is the government's role in NIMBYism? What is it allowing that offends or violates the constitutional mandates of whatever Green Amendment provision is in? And that's where the analysis will be and will stay. So it doesn't even reach the point of, a presumed pollution, or pollution plume, to determine which community gets the brunt of it. It stops at that point. So I'll give it back to you, Maya. I'm sure you have a lot of thoughts about this.
So I think that's really great and helpful. And Mel's exactly right. That's, it's by design that green amendments actually avoid this misuse of the amendment language to try to challenge things of any kind for nefarious reasons. Or inappropriate reasons. First off, the amendment itself, all green amendment language is focused on the environmental effects. That is the focus. And, we have to recognize whether it's a fossil fuel project or a housing development or a clean energy project, there are potential environmental ramifications. And there are places and spaces, right ways and wrong ways to do all of these things. If a green amendment is used to challenge a project of any kind, whether you're talking about low-income housing or any of these other projects, the green amendment will necessarily focus on what are the environmental impacts. It's not going to be focused on what is that end use, what are the environmental impacts. And if that project or initiative is going to create a significant burden on the environment, then what the Green Amendment will do is if that impact rises to the constitutional level, then what the Green Amendment will help do through that strict scrutiny analysis is ensure that to the degree there is going to be an environmental impact that rises to that constitutional level, that government officials have done their duty to try to minimize the level of that impact. And to recognize that if there is going to still be an impact that rises to that constitutional level, does the initiative that's advancing serve a compelling state interest? Low-income housing, clean energy projects. There are projects of all kinds where the climate crisis, there is a compelling state interest. So the Green Amendment doesn't say no environmental impact that rises to the constitutional level. It says if there's going to be an impact that rises to the constitutional level, you have to have that compelling state interest, and you have to do the work of making sure you're minimizing the level of the environmental impact. And I would suggest to you that that is an appropriate analysis and that is an appropriate outcome, regardless of the type of project that you're carrying forward. Because even if that project will help some group of people, you want to make sure that it's not going to harm others. And a Green Amendment analysis will help accomplish that.
Perfect. And we received another, I think it's a multi-question question. I'll just read off and then you can grab what resonates with you. How do we find solutions between farm growing crops that use urea, nitrogen, phosphorus, and potassium fertilizers to prevent it going into water without hurting food yields, supplies, and lower costs? I'll start with that and then read the rest if we have time. You should.
So to me, I mean, that's asking a question about farming and, I have thoughts about good ways and bad ways to do farming, but that seems like a very specific question. So I'm sort of feeling like maybe it needs additional context, but probably not my place to weigh in.
Yeah. Well, I think it's another example of how we can take any question or facts of a case and apply the strict scrutiny test to determine, okay, what is the government action or inaction that's causing this harm to a water body? Is, like, for instance, in Florida, the general sense is that you have best management practices that the state has presumed or requests that farms abide by. There's not a lot of verification. There's not a lot of monitoring at all. There's incentive programs to do better, but so that's kind of like the current status of things, and which is why a lot of in various places of Florida there is a large percentage of pollution created from agricultural runoff. So in that sense, how it would apply in Florida is that the state agencies would have a higher duty. They would have better regulations to implement the level of duties that they have to comply with this constitutional standard, and more enforcement, more monitoring to ensure that every actor that is using our water supply is doing the very best they can to prevent pollution and any degradation of shared resources like water. So that's just a quick example. And I know we have like 45 seconds left, but
I do just want to ask, as you were doing it in the constitutional framing. And so, and I agree with you, everything you said, right?
Okay, good.
Green Amendment raises the bar on all of this. And then just to bring it back, but we have to look for that government action that we're focused on. And so like Mel said, to the extent that government is involved, what's the permit? How's the permitting? How's the law, right? That's where the Green Amendment framing will come into play. Again, there are so many things about farms and farming, but in terms of the Green Amendment, we're going to be looking at how the government perpetuates, helps, harms. What is the outcome when it comes to natural resources and environmental rights?
Great. And I think the really quick question that you might know offhand that I don't, what is Ohio's status regarding green amendments and what they might be looking for?
So Ohio does not have a Green Amendment at this time, nor has a leader stepped forward to want to work together to advance a Green Amendment. We only will work in a state where there's an in-state leader, individual organization, progressive legislator, not even progressive, any kind of legislator, who wants to help, craft and advance the Green Amendment movement in partnership with Green Amendments for the Generations. So we don't have that yet in Ohio. And do just want to sort of looking forward to the other part of the question. You cannot use the Pennsylvania Green Amendment against Ohio government officials, right? The Pennsylvania Amendment applies to Pennsylvania government officials, Pennsylvania action, and Ohio Green Amendment will do the same for Ohio. It's one of the reasons why we need a federal Green Amendment, because that federal Green Amendment can also help with some of that cross-state impact. But writ large, the thought is that if we have a Green Amendment in every single state, then we can be having communities in those states holding their government officials accountable to that higher standard. But yeah, you're not going to use the Pennsylvania Amendment against Ohio, nor are you going to use a state Green Amendment against federal government action. That's why we need a federal Green Amendment.
You can bring it in as persuasive authority, but it definitely helps to codify your own. Okay, Carolyn, I believe that we are good to go.